Back to order. It is 10:18, and we've come out of executive session. And the next item on the agenda is 2.1, discussion and potential action. Discussion and potential action shall occur regarding pursuant to Chapter 2007 of the Texas Government Code and other authority, the approval of a takings impact assessment, or TIA as we call it, regarding the proposed subdivision and manufactured home rental community regulations for Kerr County. And the scheduling of and related notice for future public meeting of the Commissioners Court to consider approval and enactment of the regulations and all related matters. So with that, where do we begin?
You like to get on camera.
Yeah.
May it please the court,
Yes, sir.
Chuck Kimbrough, I represent the county along with Heather Stebbins regarding this matter. It is our understanding that some residents would like to take up a matter regarding the proposed draft regulations as a component of the all related matters part of your agenda item. I was thinking, would that be the appropriate thing to hear from those folks at this point before we get into the TIA matter?
It would, but where are they?
They're not out there.
I don't know where they went.
I visited with them ahead of time and want me to, for the record, talk about the issue or not.
No, let's talk about the issue because we need to have this on record. We'll have a transcript at some point, and we'll be able to refer back to exactly what we have discussed.
Just a moment. At the public hearing, a group of concerned residents, I've forgotten what the group's name was, but Ms. Janet Buchert.
It's the Centerpoint Group. We know who they are.
All right. Ms. Buchert, am I pronouncing her last name correctly?
I think so. I don't know.
Janet's her first name. I wrote a letter and then at the public hearing presented the letter and made comments. And regarding one of the issues they had with the public hearing draft, pertaining to a request by their group to modify one of the exceptions that were in the water availability portion of the regulations. The county did that in the proposed enactment draft and made sure that even if a subdivision qualified for an exception under the water availability requirements, nevertheless that subdivision would still have to comply with the Headwaters Groundwater Conservation District active rules and regulations. Another one of the issues that she spoke of at public hearing had to do with their concern about the portion of the public hearing draft wherein the model subdivision rules were recited. Did not say anything about compliance with the Headwaters Groundwater Conservation District active rules and regulations. And that matter was not adjusted by the Commissioners Court in its active, proposed for enactment draft. because of the coverage of protection existing in the regulations on that point. Should I go further to explain the court's position on that?
I think we need to clarify the court's position and the concerns, as I understand them, and I think you've accurately described them. But number one, they want to make sure that water availability studies are required for subdivisions under the model subdivisions rules portion of our regulations. And we want to clarify that, yes, they are. And they wanted to make sure that even the subdivisions under the model rules, the MSRs, are required to comply with whatever the regulations are for headwaters, which they are. And if you turn to page 21 of the rules, it provides that everything in our rules from section 1 through section 9, which are all the rules, the entire thing, the entire packet, what does it say? It's in section 5.01F A15. We believe requires that. And we discussed it in executive session with our lawyers, both the county attorney as well as our outside counsel, and we feel like the rules do cover that. The group that wanted to change the wording felt like that it might not be adequately explained or clarified that they apply. But it is our intent that the headwaters regulations have to be complied with, whether you're a subdivision under the model rules or our regular regulations. And I think that's what we're saying, isn't it?
All right, I can be even more specific.
Okay.
All right.
So what the point that I'm trying to make is we feel like their concerns are satisfied in the existing draft of the rules.
Yes, sir.
But we want them, if in the interest of cooperation, we're trying to make sure that there's absolutely no doubt that they apply.
We're both headed to the same goal.
That's right.
There are two issues, as I understand it, that you're speaking to now. That group's desire, and they've been very respectful in their comments to me, and I thank them for it, and courteous and cordial. Number one, as I understand it, their concern is that the model subdivision rules, let me back up. Kerr County is a model, what we call a model subdivision rules county, that is required under law to make and enforce for subdivision development in the unincorporated area the model subdivision rules promulgated by the state of Texas. Because Kerr County borrowed money from the Texas Water Development Board under the Distressed Areas Program of state law and the Water Development Board for the wastewater project. I've forgotten what it's called. What's the name of the wastewater project?
East Kerr County Center Point wastewater line.
All right. And when a governmental entity, local government, borrows money or obtains a grant of funds from the Water Development Board for a water or wastewater or a flood management program, there is a requirement under the law, as I understand it, in the state statutes and in the board's rules, that the county must, not may, but must, in order to get the money, make, enact, implement, and enforce the model subdivision rules. And periodically, representatives of the Water Development Board will audit the county to make sure that that implementation, or that the enactment, the implementation, and enforcement of the model subdivision rules is occurring, because that is a condition, as I understand it, of the loan agreement. So
And
it
we've
is a
complied.
it
And
is-
we've complied.
It is a highly significant priority matter to be aware of when you are a model subdivision rules county. So, in these proposed regulations, the model subdivision rules apply to certain types of configured and proposed subdivision development in Kerr County, Texas. They are what we phrase in this area of practice, what we call the smaller lot subdivisions, where there are at least 2 lots, 5 acres or less, presumed to be used for residential purposes. Those are the subdivision configuration that the model rules speak to. However, in your area of practice and procedure, there are other subdivision configurations that would not qualify for model subdivision rule treatment or governance. So it begs the question, for years, what is the county doing for the larger lot subdivisions to protect public health, safety, and welfare, particularly regarding groundwater, surface water, and wastewater and drainage issues? It was the charge from the court to staff and council to come up with some ideas and some options by which to protect health, safety, and welfare for the whole of the county in the unincorporated area, not just the specific provisions that the county was required to do because of the model subdivision rule obligation. This draft, this active draft does that, as you have endorsed and concur. Correct?
Yeah.
Correct.
Yes.
It's, as has been said from time to time, a step up in regulatory authority for this commissioner's court and the staff of the county because of one simple overriding and frankly governing principle: to do something for health, safety, and welfare, particularly in the area groundwater, surface water, drainage, and other health, safety, and welfare issues. So, the court, in its proposed for enactment draft, dealt with not just model subdivision rule governance issues for that protection to the people, but also in other parts of the draft. And it's the other parts of the draft that I think the folks that are asking for a revision have not placed enough emphasis on, okay? And that would be section 5.08 of the active draft.
Page 37.
I think that's section 5.08 that starts on page 37
Yes, sir.
and goes for several pages there.
All right. So when you turn to page 38, there are several pieces of authority there that we have been discussing. We, when I say we, Mr. Hastings' office, Ms. Stebbins' office, and my office, we've been discussing with you for a long while now, to the point where most of you on the dais are able to rattle off the statute numbers and the regulation numbers with pretty good frequency. But we know that because the county is in a priority groundwater management area, that for groundwater, there's a special water code statute, 35.019 of the water code, which allows the county to make its own water availability regulations as conditions for plat approval regarding subdivision development. That's one area of the law. It doesn't say exactly what you can do. It gives you the ability to create your own requirements given the local and factual circumstances. Next, there is a state statute out there that helps the county greatly. It's section 232.0032 of the local government code, which is available to any county in the state which chooses to adopt its regulatory power. By these regulations, you do so. 232.0032 is a groundwater certification requirement, which states in so many words that if groundwater appears to be the source for water, the human consumption of water for the subdivision, then the developer's Texas licensed engineer or geoscientist must perform a groundwater availability analysis and certify that sufficient groundwater is under that land to service the subdivision according to the methodology for 30 years. The statute itself does not provide the exact methodology to perform the study, but refers, the statutory language refers to TSEC to promulgate rules.
And TSEC, so the public understands, is TCEQ,
Yes.
the Texas Commission on Environmental Quality.
Yes. That commission is instructed to pass regulations to define the methodology about how to do the groundwater study. TSEC has done that. And on page 38, you'll see right after the reference in subparagraph C to 232.0032 of the local government code, another site, to wit, 30, TAC, that means Texas Administrative Code. Those are the books where TSEC regulations get passed and promulgated. 30, TAC, sections 230.1 through 230.11. Were the administrative regulations that the Commission on Environmental Quality enacted in response to the legislature's direct orders in the statute to make some rules to show them how to do the groundwater study. TAC 230.1 through 230.11 are the rules that show the developer how to do the 30-year groundwater study that the statute 230.0032 requires, since you are approving adoption of it.
And that applies to both the model subdivision rules subdivisions as
Yes,
well
sir.
as the larger.
You are saying on this, actually turn the page to 39. The groundwater sufficiency disclosure statement under the big paragraph A, 232.0032, that spells out what the statute says. It spells out the methodology that the legislature told TSEC to pass in the administrative regulation to tell them how to do the study, and all the other requirements of the groundwater study. Every subdivision in Kerr County that is not exempt under your regulations must do the 232.0032 30-year groundwater study. End of statement. I'm going to get to the model subdivision rules in just a moment.
Okay.
Any subdivision. That is a plain and clear reading of your proposed regulation. Do you understand?
Yes.
All right. Now go back to page 38. We were just talking about the law. Also in that subparagraph C, you'll see a reference to subchapter E of chapter 232 and subchapter C of chapter 232. Okay? C is the subchapter that applies to EDAP counties who have borrowed money from the Water Development Board.
And EDAP is
Economically Distressed Area Program of the Water Development Board.
Right.
That's subchapter C. You're a subchapter C county and a subchapter A county and a subchapter E county. I don't want to get into all that explanation again, but C is where the EDAP money comes in that you borrowed from the board. Well, what does that say in subchapter C? You must, not may, you must enact, implement, and enforce the model subdivision rules because you borrowed the money from the Water Development Board. All right? We'll get to the model subdivision rules in a moment. But subchapter E is mentioned in that paragraph. Subchapter E is available to any county in the state that wants to adopt one or more of the specific provisions in subchapter E. One of the provisions is called 232.101. And it says that a county adopting 232.101 may make regulations regarding plats and subdivisions of land to protect the public health, safety, and welfare. So long as your regulations do not violate a list of prohibited topics like zoning, for instance. Your water regulations are important under the authority that you have adopted under 232.101, because there can be nothing in these days and times more important to health, safety, and welfare than the protection of scarce ground and surface water resources. Do you agree?
We do.
Okay. So that's another support of authority for your water availability requirements. But then keep reading. Do you see the set of administrative regulations cited there? 31 TAC sections 364.1 through .72.
Yes.
Those are the model subdivision regulations that you are required to enact, implement, and enforce as a subchapter C county because of the money that you borrowed from the Texas Water Development Board for the wastewater project. Now, is there an argument, a correct argument, that the model subdivision rules do not require the groundwater availability study. There is no such correct argument. That's the most direct way that I can say it. Absolutely, the model subdivision rules require the 30-year groundwater availability statute. Okay? Now, make sure you keep your finger on page 38. And now turn to, it's up ahead in the model subdivision rules, which are typed in italics to let everybody know quickly where they are. Due to Mr. Hastings' wisdom on that point. And they start on page 17. But just flip through past the definitions till you get to around page 21 that says water facilities development. Now I'm not going to talk about the public water part, but look at page 22. These are the model subdivision rules. Non-public water system, individual water wells or other non-public water systems where they are proposed for the supply of drinking water. The subdivider shall have prepared and provide a copy of the groundwater availability study that complies with the requirements of, look at that number, 30, TAC, section 230.1 to 230.11, for individual water supply wells, etc., certifying that the long-term 30-year quantity and quality of available groundwater. All right, now go back to page 38. That's the same 30 TAC section 230.1 to 230.11 that all of your subdivisions have to follow for the groundwater study.
Unless there's
Under
that limited exemption.
232.0032, see?
Yeah.
You've got double bagging there, to use a grocery store analogy. Do you not? There's no question, at least in my mind, and there should not be in your mind. Your plain old regulations require the 30-year groundwater study under that specific methodology of 30 TAC sections 230.1 et sec. The model subdivision rules require the same groundwater availability study. End of statement. Questions? Do you understand?
That's what we wanted.
All right. Now go back to 38. I'm sorry, page 39.
Yeah.
We've already talked about the big paragraph, 232.0032, the 30-year groundwater study, double bagging on that. I want to go down to model subdivision rule compliance, D. Now clearly, you had the foresight to say under water availability regulations that, hey, if you're a model subdivision rule governed subdivision, you got to comply with the model rules. So the model rules for groundwater means you have to do the 30-year study. We've been talking about it at length here. Well, can you enact mandatory regulations in the model subdivision rules that are extra than the specific topics that the model subdivision rule or rules spell out? And the answer is yes, you can. I don't have the time to show you exactly in the model rules where they are, but there are two specific model rule regs that are on the books today. One is the model rules are superior and control over any other county regulation which would conflict with that model rule provision. Model rules are superior. They trump, they are superior to any other conflicting county reg. All right. Also, there is a specific regulation in the model rules that states plainly the county can enact additional regulations in addition to the model rules in terms of plat procedure and requirements and other health, safety, and welfare issues, so long as you don't violate or conflict a model subdivision rule. You have done so. You have done so. It is at page 21. Page 21, bottom page 21. The last part of the section preceding 5.01F3B. So it'll be the last sub-item, subparagraph of 5.01.F.3A, scope of standards. 15 is the number I want you to focus on now. It reads, the plat and all supporting documents submitted for plat approval shall comply with A, the standards including methodology of Division 2 and the requirements including methodology of Division 3, and then it goes on and it cites 31 Chapter 364, Subchapter B. Those are the model rules. That's in the model rules. You got to comply with the methodology in those two subparts. Second, B, the other requirements, including methodology for plat sufficiency and approval as described in these model rules. Okay? That's in there too. But it's C I want you to look at. And C is the addition of the other county regs that each model rule subdivision has to follow. What are we talking about? The other requirements, including methodology, described in sections 1 through 9 of the regulations which do not conflict with or are not superseded by these model rules.
And just for clarification, this sections 1 through 9
Section 1
are the entire rules, regulations that we
it's the whole book.
proposed.
It's the whole book before the certificate of adoption, which includes the water availability requirements in 5.08.
As well as the compliance with Headwaters groundwater conservation district rules
Yes, sir.
and regulations.
Yes, sir. That's the last issue. So your water availability requirements in 5.08 also say that whatever happens, the developer must comply with the active Headwaters groundwater conservation district active rules and regs.
That applies to model rules as well.
It does. Now, I would say it would apply to model rules even if you don't read the extra add-on to the model rules that the model rules allows. So the question becomes, is there a conflict? Is there a conflict between a rule that says everybody, if you're going to have water wells out there, related facilities, you have to follow the headwaters rules, their active regulations. Is there a conflict between that provision of regulation, that local provision of regulation, and the model subdivision rules? I fail to see it. There is not. There is not. So, it appears that as to the 3 points that I recall being raised by the group, Ms. Janet Buchert's group, and Commissioner-elect Mr. Paces also wrote a letter advocating an issue regarding this matter for a change. As to the exception paragraphs regarding water availability requirements to certain subdivisions, you address that after public hearing by making sure that even if a subdivision is exempt or accepted from water availability requirements, they still have to follow the model rules. They still have to follow the
Headwaters.
headwaters
Yes.
requirements.
Regulations.
All right. Second issue, do the model rules require a 30-year groundwater study? I hope we've knocked that out of the park. Yes, 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 it does. They do. Finally, does the extra add-on language to the model rules, which covers sections 1 through 9 as compliance issues, conflict with the MSRs, the model rules? There's not. There's no conflict. So we've been using the idea of the grocery store concept of double bagging. I mean, the formal way to say it is the interconnectivity or the interconnection of protection is there. For all subdivisions which are not exempt under your water availability requirements, connected into the model subdivision rules and the matters stated. The question becomes what you want to do at this point regarding the active draft. If anything.
Well, I don't want to adversely affect the timeline to get these rules enacted. That's my primary concern.
You suggested a clarification that would be added to this that I'd like you to recite and
Okay.
discuss.
That was on page 21.
Yes. Let's take a look at the add-on language on page 21.
That'd be section 5.01, cap F, 3.A,
Right.
and subparagraph 15.
After you see 31 TAC section 364.16, comma, the final phrase of that sentence reads, the other requirements, parentheses, including methodology, close parentheses, described in sections 1 through 9 of these regulations, which do not conflict with or are not superseded by these model rules. So that means they have to do all the other stuff. Commissioner, you're suggesting perhaps a parenthetical reference after 1 through 9 of these regulations to say parenthetically, including, without limitation, the water availability requirements of section 5.08 of these regulations? Does that sound about right?
Yes, sir.
Well,
Including without limitations what? Say it again.
okay, let me make sure that I've got the,
Well, it addresses the model subdivision rules. Application to the model subdivision rules.
hang on just a second. Now, state what you just said again. I didn't hear you.
You have it written down and I don't.
Oh, okay, all right. I just want to make sure I had 508 correct.
Yes.
Right.
5.08 are your water availability requirements.
Yes.
All right.
Yeah.
And so the insert point, if you were going to make it, would be after you see where it says 1 through Roman numeral 1 through Roman numeral 9 of these regulations. And then the next word is which. In that gap between the S of regulations and the W in which, the W in the word which, that's the insert point. Are you suggesting it say parentheses, including, without, limitation, the water availability requirements?
The 5.08.
Stated in
Yeah.
section 5.08 of these regulations, close parentheses. All right, so the question becomes, is that a substantive change? It is not.
We've already got it.
That's-
This is belts and suspenders.
I recommend that
Triple
because I think it helps
Yeah.
clarify.
Again, I would argue that once you say Roman numeral 1 through 9, it's the whole booklet.
Yeah.
Right.
This is just a marker, a signpost to make sure everybody knows. Now, there is one thing that we cannot solve, and that is, do any of your water availability requirements conflict with the model rules or conflict with headwaters? I would argue clearly they do not. They do not.
We don't want them to.
Yeah.
No, but the best opinion I can give you is what I think, and I think clearly they do not.
But the gist of what we're doing here is attempting to accommodate the concerns expressed by the Centerpoint Group and make sure that the water availability study requirements applied to the MSR subdivisions.
You've done it, we showed you.
And secondly, that all these subdivisions are subject to compliance with Headwaters regulations.
It also assists a layman reader to determine that at the end of that legalese paragraph, that yes, they do fit this also. And I think that's important.
Their goals are the
Because
same.
laymen have to read this or have to deal with it or could question it otherwise. So I think that would be helpful.
Their goals are the same as
Yeah.
ours.
Well, you
we're on the
must-
same page.
To add the parenthetical insert
Yeah.
is explanatory for clarification purposes. It is not a substantive departure from the spirit or the actual language of the reg that exists on the paper at this point. But if that addition is going to be made, you probably should take a motion and a second and a recorded vote to put it in before a takings impact analysis, which means right now, I mean, just so that I can give you my opinions.
So moved.
Second.
We've got a motion and a second. A record vote. In favor of this motion to add the explanatory language
To the draft.
to the draft.
And you're not voting on any regulation
Right.
today, you're just adding something to the
Language to the
regulation.
draft.
Yeah, right,
Okay.
to the draft.
So precinct 1,
Yes.
precinct 2,
Yes.
precinct 4,
Yes.
and I vote yes. Unanimous.
Okay. So that when we look at the takings impact assessment, with that addition, your question should be, do your conclusions as courts, if the TIA is approved, or is there any need to start over with the TIA? I'm going to argue to you later on, there's not, because it's not a substantive revision, it's an explanatory note for clarity. And
Well, with that, let's move on to the takings impact assessment.
okay. The statute procedure that you've chosen to follow is Chapter 2007 of the Texas Government Code. The proposed document is in front of you. It's called a Takings Impact Assessment regarding proposed subdivision and manufactured home rental community regulations for Kerr County. If approved, this is the document that would constitute your TIA. We call it an acronym, Takings Impact Assessment, TIA, under Chapter 2007. The statute empowered the Texas Attorney General's office to promulgate guidelines by which to analyze takings impact assessments applied statewide. The AG's office did so some years ago. They promulgated a 7-question analysis. But if you get to the answer on question 3 and the answer is no, under the guidelines, you're not required to answer questions 4 through 7. In my opinion, our opinion of our law firm, that is the situation today. I'll analyze it in just a moment, but based on the facts and the method of analysis, it's our judgment that the county is not required to go any farther than number 3. And number 3 concludes in the language of the statute, page 9 or 10, that there's a no private real property impact determination that's being made by the court. So you start with the idea that this document is approved. You're also making a scheduling decision today. That if the TIA is approved by a motion and a second and a recorded vote, then it's executed by the court members and the county clerk or her deputy, and it's given to the clerk to be placed in the official minutes of the court. A copy of the TIA is placed in the county judge's office for public inspection and copying. And then a special notice has to go into the newspaper that, in line with the statute itself, summarizes the proposed regulations and summarizes the findings in the TIA. And the other thing you do in that takings impact assessment notice and takings impact assessment document is you schedule your vote to consider approval, final approval and enactment of these regulations. And in this document, the date of Monday, November 28, 2022, the Monday after Thanksgiving at 9 a.m. in this building, in this room, is the date and the time and the location where you will be saying that these regulations, with the slight explanatory revision that you've added today, will come up for discussion and potential vote approval. Is that date acceptable to the court? Date, time, and location.
Yes.
Yes, we've been working on that for a long time.
Yeah.
It's my understanding under the law that there's no supermajority required, but a quorum of the court has to be there the Monday after Thanksgiving. So, from a scheduling standpoint, there's a timeline that has to play out, and I want to call it to your attention. If the TIA is approved, that special notice has to go into the newspaper. We're in contact with the Kerrville Daily Times to get such a notice in the newspaper to publish this Thursday. It would they be the 20th, correct?
Yes.
once the newspaper notice is published, no action can be taken to try to vote the regs in or take them up for approval consideration until at least 30 days expire from the date of the newspaper notice. So by my calendar calculation, November the 28th of 2022 would be the 39th day in the period. Therefore, that proposed vote day would be timely under Chapter 2007. Next, the TIA talks about, summarizes in paragraphs 7 and 8 what the regulations say. And if you quickly go through, you'll see some of the statute numbers and the Texas Administrative Code citation numbers that we've been talking about this morning. It also says that once the TIA is approved, a copy of it will be at the judge's office for the people that want to go by and inspect it and get a copy. And that
She knows what that means.
the regulations with this slight explanatory parenthetical statement on page, what was it, 21?
21.
21.
21 where it appears now, will be in there. That the draft will be placed on your website for public viewing and download, and a copy of that active enactment draft will be available at the county judge's office for public viewing and inspection and copy. Next, the TIA analysis begins with paragraph number 10. And when you turn the page, you'll see questions 1 and 2. And then later on page 6 or so, question 3. Question 1. Is Kerr County Commissioners Court, as the governing body, is Kerr County a governmental entity covered by the Act? In other words, it is a covered governmental entity. Well, clearly, the answer is yes. The county is a governmental entity, a covered governmental entity under the Act. So the answer to number 1 is yes. Question to number 2. Is the proposed action to be undertaken by the county as a covered governmental entity an action covered by the Act? In other words, are you trying to, by the passage of these regulations, engage in a covered governmental action? We argue that the answer to that question is no, because the county is exempt from coverage under or application to the Act because of the statutory exemptions, which include all of the matters that are included under subparagraph B to the answer to question 2, with explanatory paragraphs regarding those exemptions and a summary paragraph ending up with F, just above question 3. Therefore, we recommend that the correct finding to question 2 is no, because the proposed regulations are exempt from coverage under or applications to Chapter 2007 pursuant to the exception list listed in the statute, and the statute number is 2007.003, subparagraph B as in boy, and other award. And finally, question 3. Does the covered governmental action result in a burden on private real property as that term is defined in the Act? We submit that the answer to that question should be no, and the analysis of those matters go all the way to the signature line, but it boils down to this, and I'm summarizing the summary. Okay. The law of the state of Texas, whether it's the statutory law passed by the legislature or the agency law of TSEC promulgated in the Texas Administrative Code gives you the power to act, regulate, and govern as the regs describe. For one simple overriding policy reason: the protection of public health, safety, and welfare. I mean, I could say it longer and fancier, but that's been your guiding policy focus from the first day you spoke to me on the record about this. Correct?
Correct.
The law lets you do what you are trying to do in the interest of public health, safety, and welfare. And some might argue, well, are there any reasonable alternatives to these regulations that you might consider in lieu of mandatory compliance with your regulations if they're enacted? Well, perhaps one might argue you could say the same thing in another booklet, say the exact same thing, but not make the regulations mandatory. Not make the regulations enforceable under civil or criminal law as the law allows you to do. Make them voluntary and try to educate the development public to do these health, safety, and welfare tasks and components on their own by voluntary consent. The TIA takes the position that yes, alternative actions out there like that, to not have the regulations or to water them down so that they're merely best practice policy suggestions and not mandatory, make them purely regulations that would be followed only by developer consent. This document says those alternatives are not reasonable. Given your experience in this area of Texas regarding land development practice and procedure, for one overriding reason, and it's stated in this TIA. Due to the present risk for colonious or other substandard development existing in this county due to increased financial opportunities for private land development in this region of Texas, for the sale of land or for the sale of lots or other divided parts of land in the unincorporated area to the public for residential, recreational, or business development purposes. Do you agree?
Yes.
Yes.
Then the final paragraph summarizes your findings. And if it's approved, it will be that you have determined that the proposed action of the county, meaning the enactment of the regs, has been fully assessed for its potential impact on private real property, and that the proposed action of the county is exempt from coverage under or application to Chapter 2007. And 3, finally, that a, quote, no private real property impact determination, close quote, is made by the county in this TIA regarding the proposed enactment of the regulations, and no further compliance with or analysis under the AG guidelines or Chapter 2007 is required, because the answer to question 3 is no. Questions regarding the TIA, the scheduling procedure, the public notice, the regs, or anything else?
No.
I recommend that you, through a recorded motion, second, and a recorded public vote, approve the proposed takings impact assessment as stated in the proposed draft.
So moved.
Second.
Have a motion and a second to approve the takings impact assessment regarding the proposed subdivision and manufactured home rental community regulations for Kirk County to be approved as presented. Any discussion? Record vote, precinct 1,
Yes.
precinct 2,
Yes.
precinct 4,
Yes.
and I vote yes, unanimous, 4-0.
Thank you.
Thank you.
I have some follow-up work to do with Jody.
Okay. There being no other business before the court at this time, we are adjourned.